Welcome everybody. My name is Merrick Garland. I'm going to be the moderator today. This morning's topic is the Internet revolution and its effect on the First Amendment. We're going to begin with a panel discussion that should last about a half an hour. We've asked the timekeepers to let us know when we've got about 10 minutes left. Then after the panel discussion, we'll have about 30 minutes for questions from you. We're going to have a roving mic, so all you have to do is raise your hand and the mic will come to you. And then we'll have another about 15 minutes for you guys to talk to the panelists informally before the powers that be shoo us out of here. And there's a lunch after this, I understand. I'm going to introduce the panel now. We have a very interesting and knowledgeable panel for you. Immediately to my left is Cliff Sloan. Cliff is a partner in the intellectual property group at the Skadden Arps law firm. He was previously the general counsel at Washington Post, Newsweek Interactive, and he was the publisher of Slate magazine. Cliff served as associate counsel to the President of the United States from 1993 to 1995 and was assistant to the Solicitor General from 1989 to 1991. He's argued 5 cases in the Supreme Court. He clerked for D.C. Circuit Judge J. Skelly Wright and for Justice John Paul Stevens. Now that is the official biography. Those of you who watch late-night television, at least for me it's late, know that Cliff is a 3-time guest on the Colbert Report. In that role, Cliff has publicly vetted Mr. Colbert for a position in President Obama's cabinet. Cliff asked a lot of questions, but there was only one question that really mattered, which was, quote, "Have you ever done anything that would embarrass the president?" If you've ever seen the Colbert Report, you know what the answer to that question was. Suffice it to say that it did not take Mr. Colbert very long to realize that Cliff doubted that he had a cabinet position in his future. Colbert responded in the only way that he could. He attempted to slip Cliff a roll of cash. Next to the left is Greg McCurdy. Greg is Senior Policy Counsel for Microsoft. He joined Microsoft in 2000 and was based at Microsoft's European headquarters in Paris until 2002. That is not a bad assignment. Before joining Microsoft, Greg was a litigator at Milbank Tweed and at Proskauer Rose. He served as a law clerk for my colleague Harry Edwards, as well as for Judge Harold Baer at the Southern District of New York. Greg graduated from NYU Law School, where he was editor of the Journal of International Law and Politics, and from Harvard College. Greg has not appeared on the Colbert Report. Paul Smith is next. He's a partner at Jenner & Block, where he's chair of the appellate and Supreme Court practice and co-chair of the creative content and media and First Amendment practice. He has argued 13 cases before the Supreme Court, more than Cliff or any other panelist, although, like Greg, he has not appeared on the Colbert Report. He's former chair of the National Board of Directors of this institution, the American Constitution Society, former member of the Board of Governors of the District of Columbia Bar. He's currently co-chair of the Board of Directors of Lambda Legal and a member of the board of the Washington Lawyers Committee for Civil Rights and Urban Affairs. He clerked for Second Circuit, not Circus. This applies to me too, so. Judge James Oakes and for Justice Lewis Powell. Next is Lee Tien. Lee is a senior staff attorney with the Electronic Frontier Foundation, specializing in free speech and privacy law. Before joining EFF, Lee was a sole practitioner specializing in Freedom of Information Act litigation. He received his undergraduate degree in psychology from Stanford, where he was active in journalism at the Stanford Daily. After working as a news reporter at the Tacoma News Tribune, Lee attended law school at Boalt Hall. It will not surprise you that Lee did not appear on the Colbert Report. And finally, Ann Beeson. Ann is the director of U.S. programs for the Open Society Institute. She joined OSI in June of 2007. Before that, she was associate legal director of the ACLU. She has argued 2 Supreme Court cases. She is a graduate of Emory University School of Law, where she was editor-in-chief of the Law Review, and she has a master's degree from the University of Texas. Now again, that is Ann's official biography. But as a member of a panel about the Internet, I thought a little Googling might be in order. with apologies to Microsoft here. Yeah. And sure enough, a 2007 New York Times article about Anne is considerably more colorful, and literally so. The Times wrote, quote, "Ms. Beeson and the sounds of silence are an oil and water proposition. She is, after all, a Texan. She talks with a twang and tells it like a storyteller, even when she's arguing before the United States Supreme Court, which, as a top lawyer for the ACLU, she has done twice, successfully. Wearing orange, her signature shade both times. Even her favorite color is noisy," close quote. No, Anne has not appeared on Colbert, but apparently she should have. All right, so we're now going to begin with a discussion of the topic. I've asked each of the members of the panel to prepare a 5-minute answer to the question of what are the greatest advantages, biggest opportunities that the Internet provides to expand free speech, and or what is the biggest threat to free speech caused by the Internet. Everybody will have a 5-minute answer to that. Cliff will begin with a brief overview of the topic of free speech and the Internet, and because he's doing double duty, I'm going to cut him a little slack on the time. The panelists have also agreed that I should feel completely free to interrupt them at any time with fierce cross-examination questions. At least I think they agreed to that. So, without further ado, and without the Colbert introductory music, we begin with Cliff Sloan.
Thank you, Stephen. Judge. And it's great to be here this morning. As Judge Garland mentioned, I have been asked to give a brief comment on the history of the Internet and the First Amendment. I was told not to exceed 60 seconds, so which is a little bit, I don't know if you're fans of reduced Shakespeare, Hamlet in 3 minutes, so it's going to be very high level. So just a couple of very brief points. One of them, I think, when you look at the history of the Internet and the First Amendment, there are sort of two competing visions of the role of the Internet and the First Amendment. And this has been true from the first days of the Internet, and they're true today, and they're both very important. And one vision is of the Internet as the spark, the vehicle, the forum for a revolution in free speech, for an explosion of free speech. And the other is seeing the Internet as a spark, a vehicle, a forum for unprecedented suppression of free speech through surveillance, through censorship, through abuse and harassment of various kinds. And I think there are elements of truth to both, and I think that's actually one of the reasons why it's very important that all of us and the larger community stays very involved and engaged on these issues, so that the Internet can be realizing its full potential, and so that the sort of dark scenarios about the Internet can be kept at bay as much as possible. Also, I think two developments very early in the Internet have been very important in clearing the way for the Internet to have a very broad and rich potential for free speech. One of them was the Reno versus ACLU case, which some members of the panel were very involved in, which established that the highest form of First Amendment protection applied to the Internet. It was argued vehemently to the contrary on the other side, and I think it's justly been called the Magna Carta of cyberspace. And secondly, Section 230 of the Communications Act, which, broadly speaking, gives immunity, except for intellectual property claims, for content provided by another. And what that has done is allowed a very wide range of sites to embrace user comments and all kinds of speech on the Internet without fearing liability if they didn't pre-screen every comment, whether you're talking about cooking sites, political sites, sports sites, news sites, and on and on. And I think that also has been a very important principle. Just briefly, picking up on the question that Judge Garland posed at the outset about a couple of opportunities for free speech on the Internet and a couple of threats, and the some of the leading opportunities that I see. Let me mention two. And one is much greater citizen involvement and participation in radically new ways in government, and I would also say in corporate governance. But in government, we see a real effort by the administration and by the White House. This has been very, very important to try to figure out ways of opening up the government information systems to much greater citizen participation. I think there's going to be a lot of experimentation along these lines. Some things are going to work well, some things aren't, but I think it's going to be very exciting. Beth Novak, formerly of NYU Law School, now Deputy CTO in the White House, is in charge of this open governance initiative, and she has a wonderful new book called Wiki Government, which I recommend to all of you.
Cliff, by the way, has a wonderful new book on Marbury versus Madison.
Thank you. Wiki Government, Marbury versus Madison. You can see the, yes, but thank you for that. And
during the networking period, he'll be signing.
And I think we can see similar opportunities in the field of corporate governance, including for much greater transparency. So I think that's going to be a very exciting area. The second area of opportunity, and it's going to be interesting to see things come full circle on this, is that because of the Internet and the convergence of media, I think we finally are going to see the overturning of the doctrine that broadcast speech gets a lower level of First Amendment protection. Remember, it was premised on an idea of scarcity and the unique role of broadcasting, none of which makes any sense or holds true now. And, of course, this term, there was the indecency decision by the Supreme Court, and which upheld the FCC's indecency findings as a matter of administrative law, but remanded and left open the First Amendment question. That'll be litigated now, and one justice staked out a very pro-First Amendment position, said the underpinnings of that reduced First Amendment are gone and should be abandoned. That justice was Justice Clarence Thomas. So it'll be very interesting to see what happens with that. And then just very briefly, a couple of threats, I think, involving the Internet and free speech. The first is this problem of censorship and surveillance in different countries, and of course, we have been seeing the news accounts of China and the Green Dam Project, this new software that's supposed to be in place in July, which would impose censorship. But in many countries around the world, there are all kinds of censorship regimes going on the Internet. Of course, you look at Iran and Twitter, and you see uses of the Internet to get around authoritative governmental efforts. And the last point I want to mention is the subject of piracy, theft of intellectual property on the Internet. And that may seem a bit unusual to bring up in a First Amendment panel, but I think that is actually a real threat to free speech on the Internet. There is this rampant problem of piracy. I want to emphasize, I'm talking here about content that is clearly stolen, pirated. I'm not getting into issues about fair use that we can have a healthy disagreement on. I'm talking about content that everybody in the room would agree is stolen, and there is very rampant piracy, totaling billions of dollars, and I do think that's a threat to speech on the Internet.
So I take it that as the former counsel of Newsweek, Washington Post Interactive, you don't think the likely demise of both of those institutions is a threat to free speech?
Well, I would, first of all, not agree with the premise of the question. But no, look, I think the challenges to journalism are a real threat, and to quality journalism. I don't think that's a question, as it is sometimes posed, of the Internet destroying journalism. In fact, the Internet has been a fantastic vehicle for quality journalism. And one of the things that gets lost in the discussions about the death of newspapers or the death of magazines is that people are flocking to quality journalism online, to sites like WashingtonPost.com, Newsweek.com, the New York Times site, and on and on. There's a problem with the business model right now, and it's a very serious problem, and quality journalism requires a lot of money if you're going to, somebody said talk is cheap but reporting is expensive, and it takes a lot of money to have foreign correspondence, which is really important, and we can get into a lot of things about the business model. But I don't think that question is a question of Internet versus print. And I think that's actually a sort of a misconception to frame it that way.
Let's hold that because I think Ann wants to talk about that during her 5.
I was actually going to jump in. I just can't resist
good.
the urge to amplify Cliff's earlier comments about the important milestones in the history of free speech on the Internet. I was, as some of you know, a very lucky kid in that pretty much the first case I ever filed in court was the Reno versus ACLU case. And I just want, especially for the students in the room, and I'm hoping there are lots of you out there, for you to understand that when we were putting this case together with our dear colleagues at Jenner and Block, Paul's colleagues, we were absolutely convinced that we were going to lose this case. In the sense of we thought that the court would hold that the broadcast rules would apply to the Internet. And there was a very serious conversation among us, the lawyers that wanted to win, about whether or not we even had a strong enough case to challenge what were actually 2 different provisions of the Communications Decency Act. One was the display provision, right, which prohibited displaying indecency on the Internet, and the other one was the provision that made it illegal to send directly by email, right, indecent communications. And our friends, I have to poke fun, our friends at Jenner and Block were especially convinced that we wouldn't be able to win the argument that it should be constitutional under the First Amendment on the Internet to send indecency directly to a minor. And I'm also happy to report that we twisted the arms of our friends and we convinced them that no, we should challenge both, and we won. And I only make that point, for you to understand, that it really was a very critical time, and I think it's a critical time again with different issues, and the other panelists are going to raise those issues up. But it was a very critical time, which would have made a very big difference in terms of the outcome of that one case, and to see that even in retrospect, it looks like, well, of course the court held, that the print rules, the strongest protection should apply. It wasn't at all clear at the time that was going to be the outcome. So,
Paul, do you want a rebuttal on this? Or?
It's a kind of an interesting revisionist history.
It was not.
I don't remember it that way. It was a remarkable time, though. This was a time when the judges we were dealing with, both in the 3-judge court in Philadelphia and up in the Supreme Court, didn't know what the Internet was. And it was only 12, 13 years ago. We had to set up the computers in the courtroom and show them this is a website, and you access it with a mouse, and you click on it, and it goes places and things like that. And so they had one in the Supreme Court library set up so that the Supreme Court justices would come up and see what a website was in 1997. So it's amazing how things have changed. And what the government's position is that the Internet should be subject to the same level of regulation as broadcast television, meaning that anything that's not fit for an 8-year-old child should not be open to anybody on the Internet. It would have to be behind some screen with a credit card entry and things like that. I think we all thought it was terribly unconstitutional, Ann, I must say. But anyway,
we did.
If that had been the law, obviously the whole world would have changed. And so this really, I think it aptly is named as sort of the Magna Carta of the Internet.
All right, Greg, you want to take your time?
Thank you, Judge. Good morning, everybody. The screen that you just mentioned is actually an interesting jumping-off point for me, and the Communications Decency Act is as well, because in my current role at Microsoft, I've had sort of 3 different jobs. My current one is as the policy lawyer for our state government affairs team, and we cover all 50 states, and I'm the guy who monitors legislation and helps deal with our relations with attorneys general. And legislatures and attorneys general are very interested in regulating what goes on the Internet. They have a lot of concerns about safety for children in particular on social networking sites. They certain indecency things on sites like maybe Craigslist concern them from time to time. So these are very live political issues. In terms of what are the great benefits and the future growth of the Internet, which was sort of the jumping-off question that we had, I mean, I think, the sky's the limit. We've seen incredible growth and advancement in it, and we're very much still at the beginning. Bandwidth is going to be spreading more and more widely around the world, and more people will have access to high bandwidth pipes that will get high quality content into wherever they have a computer or other device that can receive it, because it's certainly not limited to computers anymore. On the software and services side, there are going to be incredible advancements. You've seen in recent years things like Facebook or MySpace or Twitter that nobody would have dreamed of not too long ago, all of a sudden becoming very important. social phenomena, economic phenomena, political phenomena, and that is because somebody thought of a business model, invented software to make it happen. So that's all great. Lots of opportunity for speech, for content to be exchanged around the world. The threats, as we were just discussing, indeed come from governments and regulators that for policy and political reasons want to clamp down on that speech. And some of those reasons I think are very legitimate, and others are perhaps more questionable. As a service provider and a technology company, Microsoft has to think of, well, how do you respond? You serve customers, you want to provide services and products that people use, and that generate revenues for your company and your shareholders, depending on your business model. Be that advertising, be that subscription-based fees, be that licensing royalties or what have you. And business models are very important on the online world, as unfortunately the traditional media are finding out right now. So those are great issues of concern. One other thing to think about in terms of the internet is that on the one hand, it's very much like the rest of the world, the physical world, and on the other hand, it's different in some ways. So a lot of the problems you see, it's sometimes instructive to look to the traditional physical world to see how those are solved. In terms of access to indecent content or the wrong people congregating in certain places, well, attorneys general and others are proposing that social networking sites like MySpace and Facebook have age verification. And some people have said, as Paul mentioned, a credit card verification system. I've heard at least one attorney general say that. Now, unfortunately, that's not really very effective. First of all, any kid can get their hands on mommy and daddy's credit cards. So, the credit card doesn't guarantee that whoever claims to be an adult isn't really a kid with their parents' credit card. And secondly, the credit card industry isn't very interested in having their payment verification system used as a sort of shadow identification system. So I think in terms of how to implement legitimate concerns about, keeping minors off of certain sites. I mean, MySpace and Facebook have a 13-year, you have to be 13 years old as a minimum. That's their terms of service. That's not a government mandate, but that's what they impose themselves. Now, they have no way of policing that. Many 11 and 12-year-olds now go on these sites and register and claim to be 14 and 15, and there's absolutely nothing that these service providers can do, and legislators are struggling for ways to correct that problem because they're worried that, well, then they'll come into contact with adults who are up to no good, and they might want to restrict adults from accessing certain sites. So there's a fundamental piece of infrastructure that's missing on the internet that we have developed in the real world, and that's reliable identification. If you take a driver's license, which in this country is sort of the main form of identification, we accept that, to get on airplanes, to buy alcohol, and all sorts of things. It's a voluntary system. You need it if you want to access these various services, but it's pretty effective. And some of us at Microsoft have been thinking about that, and Scott Charney is our Vice President for Trustworthy Computing, and he's made a proposal to the state attorneys general and to others that we develop a system whereby certain types of ID can be obtained that are reliable, that can be stuck into a computer that reads a card and a chip that is more reliable than a credit card, that is not easy to steal or to fake, and that can provide us with some way of having appropriate regulations that are not overbroad, that do not unduly stifle speech, but that are also effective in certain circumstances where the law deems it necessary.
Greg, why does he think that if it's easy to steal Daddy's credit card, it wouldn't be easy to steal Dad's computer chip? Particularly since the kid is more likely to know something about the computer chip than the daddy.
It's certainly a matter of degree. Why do we give more credence to a driver's license or a passport than to a credit card? First of all, you probably have 5 credit cards in your wallet, and you don't pay as much attention to them as you do to your passport or your driver's license. We don't accept any old piece of plastic for identification purposes. So there's ways of restricting it, and then it's certainly not going to be perfect, but I think most adults keep better track of their driver's license than they do of their credit cards. And secondly, the credit card companies are not excited about having their system used for that. The sort of proposal is to have micro charges. In order to use the website, you have to charge something. The credit card then says, oh, well, this is a valid credit card. Of course, that says nothing about who's actually using the credit card in that transaction. And, fees are incurred, and, it's just a system that wasn't designed for that. So a lot of kinks need to be ironed out. It's something that you'd have to have, state authorities, you'd have to have schools, you'd have to have, departments of motor vehicles cooperate on.
Okay, thanks. Paul, what have you got to say?
Thanks, Judge. In terms of how the Internet has promoted free speech, I think the answer is sort of obvious and indeed has already been said. When Ann and I were in my firm and Ann at ECLU were working on that first case, what we tried to prove to the court was that, as Judge Dalzell actually put it ultimately in the opinion in the trial court, the Internet is the most participatory form of mass speech yet developed, and therefore it needs to be protected and treasured. And indeed, that's what the courts did. And certainly the Internet, since we convinced them of that when it hadn't actually happened yet, has certainly turned into that. You now have an amazing amount of participation in speech, people able to reach the worldwide audiences who used to be trying to hand out a handbill in their little small town somewhere. And so communication has been vastly facilitated. The challenges, though, that it creates in terms of really effective speech are also clear because as we've seen this proliferation of different people speaking and this huge cacophony of material being distributed around the Internet, the question ultimately is what level of really effective speech will there be, and will people be able to find places to get information that will be reliable in a post sort of institutional journalism era, if that ultimately comes about. It was sort of somewhat heartening to hear Cliff is not as pessimistic as the rest of the world about whether there will in fact be remnants of institutional journalism where there are editors who you know and trust to tell you what information has been vetted and cleared, and maybe even do a little investigative journalism in the future, which many people think may not be possible given the economics of the situation. A world in which there are a million different people commenting on stuff constantly is talk and not, in fact, journalism. And I think that ultimately is threatening. This may just be me showing my age, that you value the things you liked when you were younger, but maybe it'll all work itself out. But I think it is very challenging. The other thing that I would point to as a challenge with the Internet in terms of actually promoting speech, it somewhat picks up on things that Greg was talking about. I think one of the costs of the Internet is, if it becomes effectively the place to go obtain information, is that there is always at least a looming threat that whatever you do as a reader will someday be tracked down by somebody else, and they'll say, well, you went and looked at this site and looked at this information, and we have a permanent record that you did. And that is a fundamental change from a physical world where people could go into a bookstore, pull a book off the shelf, read it, go to a library where there was very strong institutional protections for anonymity. People could do investigative journalism without having everything they do be recorded somewhere. But in the world both of email and of websites, you have at least concerns that all of the work that you're doing as you're sitting in your home office, traveling the world and speaking to people and recording information and finding new information will eventually be available to somebody who wants to follow all the steps you've taken. And I think that is a loss in terms of the ability of people to be anonymous recipients of information. Those of us who are lawyers in Washington were interested in the time of the transition, at least if you're on the more progressive side of the aisle, to watch the process of vetting that the Obama administration put on. And there was this long questionnaire that was handed out to everybody who wanted a political position in the Obama administration. And one of the questions was, give me every screen name you've ever used in any place, every password you've ever used for any website, and we're gonna check out what's there, And so this is the world that we now live in.
Oh, and access to your Facebook and MySpace account.
Absolutely, all of that.
So it wasn't only Colbert who failed.
So, I mean, this is a difficult, maybe it's only for lawyers who want to go into administration somewhere, have to worry about it now, but I think in the long run, this will be a concern that people have, that they're sort of, and, does Seymour Hersh get to do things as effectively when all the books are on Google as opposed to on a shelf somewhere? I mean, these are concerns, at least I would raise, and I think we should talk about.
Lee?
Thank you, Judge. I work for a group called the Electronic Frontier Foundation, and in many ways, we are a sort of 911 phone call for the Internet. We get a lot of complaints, whines, gripes from users, researchers, and innovators. One of the issues that keeps coming up, and has come up for us for many, many years, has been users who are complaining about someone trying to shut them up. And it is usually in the context of maybe you've got a website, but your web host doesn't like what you've got there. You're a blogger, but you're a blog hoster, et cetera, et cetera. Professor Seth Krimer of the University of Pennsylvania Law School wrote an article a few years ago about this problem. It's called Censorship by Proxy, Internet Intermediaries and the Problem of the Weakest Link. And that weakest link problem, the issue of Internet intermediaries, is what we see as one of the really looming threats to speech on the Internet. It's not a new threat, and it's not a new threat to speech. I mean, one of the nice things about the First Amendment itself is that it mentions not only, freedom of speech, but freedom of the press. And the press was the great institutional intermediary of olden days. And, those of us who, think about the history of free speech, remember that prior restraint doctrine was born in a history of censorship, of the licensure of the printing press, that concerns about speech and religion were often used with the stationer's copyright and, again, the printing press in England. There has always been a long tradition of putting pressure on the middleman, the choke point, the gatekeeper, to prevent the speech of everyday people, or even of the powerful people, from reaching their audience. Now, when Congress, back in 1996, as our other panelists have already talked about, enacted Section 230 of the Communications Act, they did an amazing thing for speech on the Internet. I dare say it would be very hard to imagine the kind of speech marketplace of ideas today if they did not have, if ISPs and websites and other interactive service providers did not have the kind of immunity they enjoy from communicative torts such as defamation, or from many state laws that would otherwise be applied to put pressure on them. But I think we can fairly say that those threats have only receded and have not gone away. There are quite a few recent examples. Think about Craigslist being hounded by state attorneys general for their carriage of erotic services ads, or the kinds of pressure that the state attorney generals have put on MySpace and Facebook with respect to screening who uses those services in order to try to eliminate the threat to child safety that they believe is posed by the presence of convicted sex offenders. What I guess I want to suggest here is that we have actually really two dimensions here of this concern for intermediaries and a number of new threat models. The two dimensions are, on the one hand, the liability of an intermediary for the acts or speech of its users, and on the other hand, something that is a little less dealt with by the law is the possibility or the kinds of things that intermediaries will do to their users for what their users do. Examples would be, in current legislation, we've got the Safety Act, which is, again, aimed against child pornography, et cetera, but contains a provision that would require ISPs to do mandatory data retention of traffic data about what its users do on their services. And this is something we have not yet had. This is something we have thought about every several years, usually in the context of controlling sex online. But this is a situation where you look at it structurally and you say, well, the ISPs are going to be put in a position of ratting out their users because, well, they're the most convenient and easy folks to put there.
Lee, is your group's view that there are any of these kind of things, subpoenas for the identity of somebody who is libeling somebody on their site, or notice and takedown, for example, using the same kind of procedure that's applied to copyright, that all these are inappropriate restraints on free speech?
We think they're really dangerous to free speech.
I'm asking whether they're inappropriate. So let's the typical.
It's like being in court.
Let me give you an example.
So let me give you an example. So here's the hypothetical. So there's a group that's being hosted, and some blogger on it says that Lee Tien is a serial axe murderer, and by the way, he also takes bribes from Microsoft. Both of which are false. Both of which are false. But they're, say they're libelous on their face. And you notify Verizon, or you notify AutoAdmit, or whatever the group is, that these are false on their face. Please take them down. You think that any kind of restraint, either one that, I'm going to use restraint in a loose way, either one that would permit, after you show that in fact you're not an axe murderer and that you haven't taken any bribes, which would either allow you to find out the identity of the person saying this, or that would require the hosting group to take it down. Either of these is a threat, a dangerous threat to free speech?
Well, I think they are. I mean, what we at EFF have taken the position in the courts over and over again that, you know, the point of Section 230 and the point of this kind of intermediary immunity is not to completely destroy the cause of action for defamation, but to allow the intermediary to continue as a free speech platform and not cause it to really to suffer costs that it should not, that would make it dry up.
Right.
And
so but
instance,
in the hypothetical I'm giving you, where you can show to the intermediary, let me add a third one, EFF fires you because they cannot stand having somebody who is on 5,000 blog posts listed as an axe murderer. That's just too much even for them.
Well, we've supported, you know, the test, right? There is the test that comes out in the Dendrites in New Jersey, and then also a couple of other cases where what we have argued over and over again is that, yes, a plaintiff should be able to get the identity if they can make a prima facie case for the defamation and ensure that the court actually considers the potential chilling effects of the action. And so, for instance, we've litigated many of these kinds of cases, the Doe cases, where folks want to try to get the identities of a speaker. Of course, most of the time, the actual rationale for doing so is not to use the courts. It is to retaliate against the individual in some extrajudicial way. Many of the early cases on which we formed our position were situations where companies felt that they were being threatened in their business or sort of suffering a business libel because an employee was truthfully saying something about bad practices in a pseudonymous way in a chat room. And the companies would go and get a subpoena, find out the identity, and then just discipline or fire the person. They were actually simply using the courts, using discovery and subpoenas as their own sort of enforcement arm, which of course we thought, and all of the civil liberties groups thought, was a really inappropriate use of the subpoena. So what we have tried to do over and over again is to ensure that any kinds of tools like that are ringed around by First Amendment prophylaxis to make sure that there really is some sort of evidentiary basis for the allegations in the first place, and to make sure that the attempt to get the identity information is an efficient expedition. We've seen cases where people try to get these identities where they can't even point to you come back and say, look, show us what is the defamatory statement. They can't identify it. Or here is a list of who we want to know identities of. It's pages and pages long. There has been an enormous abuse of these kinds of processes, and that's precisely why you need to have this kind of protection for intermediaries, because in our modern day legal system, the costs of dealing with these things become very high for the intermediaries. I don't usually represent the intermediaries, but we know when we deal with Yahoo or any of these groups who are often working on these kinds of situations, that it's a big, big burden. And if they really weren't committed or they didn't have the kind of immunity, then a lot of these fora would dry up.
I just want to jump in for 1 second, because I've been involved in some of these cases on behalf of media websites that have received subpoenas, and I just want to highlight and actually reemphasize a couple things that Lee was saying, which is, first of all, there is a real problem with what could be viewed as kind of abusive subpoenas, and there are guidebooks that are out there for corporations that say if somebody's criticizing your company, if you want to know who it is, just file a John Doe case, subpoena the information. It doesn't matter if you want to go forward with it. It's a great way to get information on who your anonymous critics are out there. And this is being litigated in a lot of state courts, and there's an emerging consensus, and Lee mentioned the Dendrite standard, which basically sets up a fairly rigorous threshold, but it's not absolute immunity. So the problem you were talking about doesn't come up, but you need to show some of the factors that Lee was talking about, a prima facie case, that you've tried to reach the person, and there are other hurdles, so that it doesn't become just a kind of a routine abusive option. And I think from the perspective of media websites, that is very important, because if you don't have some substantial hurdle for enforcement of these subpoenas, it's going to really burden the media website's choice to have a lot of user comments if they're going to face an avalanche of subpoenas.
So you are okay with, as long as there's some kind of threshold high enough for that you want, to require disclosure under those circumstances.
Yes.
What would you think then about the other possibility, which is so that the copyright is exempted from the immunity provided by Section 204. But there is a notice and takedown, and there is a notice and takedown requirement in the Digital Millennium Copyright Act, which says that if you're a site and an owner of intellectual property shows you that somebody is on your site violating their copyright, you have an opportunity to take it down. But if you don't take it down, you could be sued, right? What would you think about extending that to defamation or libel, again, with whatever level of threshold you want? Not just finding out the identity, but requiring a takedown.
Well, I mean, let's see. I think this emerging consensus, actually, which has been, it's sort of this trial and error among state courts in getting there. My personal view is that is sort of striking the right balance right now as a kind of deterrent on the front end, and I wouldn't favor going to a notice and takedown regime, but
I think one of the things that we know now from experience with the DMCA notice and takedown regime is it's largely a failure, at least from the standpoint of making the ISP a true sort of middleman that doesn't have a stake one way or the other. The pattern of behavior that's come out as a result of the DMCA notice and takedown is highly skewed. It tends to favor the takedown, but not the putback, right? Because that was the true theoretical symmetry of DMCA notice and takedown, is that once the purported copyright owner sent a notice to the ISP, then the poster of the material would be able to send the putback, and then the ISP would have a safe harbor if it put the material back. But what we see is that almost never happens. And of course, when you think about who is the one that is noticed, who are the entities that are noticing the takedown, they are big companies, usually. They are usually, repeat players with a lot of economic power. And who are the folks who are asking to have stuff put back? It's individual users. That is such an elephant in mice sort of situation that it's just going to be very skewed. So I worry that any kind of notice and takedown and put back regime that isn't extremely sensitive to those kinds of power issues will also be skewed.
Okay, let's have Ann have a chance for her 5, and then everybody can mix it up.
Sure. I'm going to flip the question and start with the threats first, and make an observation, which I'm sure is an oversimplification, which is that kind of looking back at the history of these debates around free speech on the internet, it seems to me that the first wave of threats had to do primarily with a wave of federal and state attempts to censor various kinds of content on the internet. So the first wave of threats had to do with censorship. The second wave of threats, which is sort of the time period we're in right now, I believe has more to do with the failure to ensure access to information and content on the internet that is absolutely critical to a vibrant democracy. And I want to just highlight 3 different examples of these big issues that have to do with access to information and content. The first, of course, has been mentioned by some of the other panelists, which is the utter crumbling of the business model for journalism, which the internet, of course, was one contributor to. Certainly not the only one. The decline in advertising revenues and the economic crisis and all of these things kind of converging to create a perfect storm, which is basically making traditional journalism, disappear. I mean, and I don't think that we can emphasize this point enough and then talk about what the internet might do to help solve the crisis. It's really the case that we could shortly become the first advanced democracy to leave wide sectors of society and geographic regions without any fully functional press at all. That's really starting to happen in certain, and certainly in small cities and towns, and shortly there may be a major city without a daily newspaper. So it's a serious crisis. That's the first example. The second one is the digital divide itself, which is still very much with us, and with the internet having become more and more critical in terms of getting access to services and information of all kinds, it's even more critical that we ensure that everyone has equal access to the internet, and that is not true yet today. And then finally, and again, this is both a threat and also a positive piece of it, whether or not the government is providing the information that it can and should provide over the internet about what it's up to. Thank goodness President Obama, made it a kind of signature statement on pretty much the second day in office, transparency, a signature statement, but we're starting to see whether it's actually getting played out in practice around the Recovery Act, for example. And I actually just came from another conference this morning in which a whole bunch of transparency groups and groups working on equity in the recovery were getting together to discuss the demands that they are needing to make on the federal government to make the data that's online right now much more granular, so that we as citizens can understand what is happening to all these federal dollars that are now flowing to the states and down to communities. So I think that there is also a potential threat if if the government doesn't step forward and make this information available as widely as it could. It's funny, one of the pleasures of my job now. I'm in a different role, working for a terrific foundation, is that I don't have to spend all my time in rooms full of lawyers like this one. I'll make that little joke.
Well, thanks a lot.
I love you all dearly. I also get to spend time in rooms full of many other amazing activists like yourselves, many other amazing advocates who use tools other than just the law to hold their government accountable. And there was an amazing conference a few weeks ago in New York that was put on by the Grassroots Media. I'm sorry, I wanted to mention the other one first, still on the threat side. I was at a conference in New York that the Columbia Journalism School put on about watchdog journalism. And, on the one hand, it felt like a wake. It really did, because you had a lot of traditional journalists there bemoaning the state of journalism, right? But on the other hand, and this kind of goes to moving me towards the potential for free speech on the Internet, some of the new business models that are emerging for journalism on the Internet are quite amazing, and I personally believe that ultimately the technology will save the day and a new model will emerge, and I think we should all watch them and be and that the government itself should be actively encouraging the development of these new models for citizen journalism on the Internet. Just to mention, a couple. One, Voice of San Diego being an amazing online newspaper that sprung up in part to replace the decline of the daily paper there. Another being sites like the Talking Points Memo, which is really an investigative journalism blogging site. And I really do think that the greatest potential for the Internet is to encourage this deeper, the deeper potential for citizen engagement and advocacy and activism and government transparency. There was another conference a few weeks later that the Grassroots Media Coalition put on. And here, if you were in that space, you couldn't go away not believing that the First Amendment and free speech were going to rule the day on the Internet. And I just wanted to just mention a few of even just the panels that were discussed there, just to give you a flavor of the kind of amazing advocacy that has been made possible by this new technology. One of them was about green map making, a communications and environmental justice tool, and it was an amazing group of environmental activists that had come together to create these maps on the Internet to show the impact of sort of both bad decisions and good ones in terms of climate change and the environment. The second one was called Mobile Media Means Media Activism, and it was all about how in Africa and Latin America, AIDS activists, citizen journalists, and many others were using cell phone technology being a very big deal to advocate for rights, as broad as you could possibly imagine. And then finally, my favorite, there was a panel called Twitter Love, a practical guide to outreach with tweets. And many of you probably read, and this was, again, another milestone, I think, for sort of free speech on the Internet, that the White House actually, sent a message directly to the Twitter folks to make sure that they weren't going to do this maintenance of the Twitter site because activists in Iran were using the technology to talk about what was going on with the election over there.
Let's talk about that for a second. So
yeah.
I heard the Secretary of State on the news yesterday morning say she didn't know the difference between tweeter and Twitter, but she understood that one or the other of them was very important in the Iranian election. Could you say something about how it has been important with respect to organizing demonstrations against the regime?
Well, again, and this goes to kind of make this link back to, both, the merging really of what we would have called more traditional forms of citizen activism and journalism, right? What's happening, of course, is that many major media outlets don't have people there now. And so you have these Iranians over there who are both using their phones and various forms of technology to take pictures and to send messages to one another to report on what their government is actually doing in Iran.
One of the other panelists mentioned concerns about censorship and ability to shut this down. Why have they not been able to shut this down?
Well, they actually have shut quite a bit of it down in Iran. I mean, this is really the point that I was trying to make earlier about this censorship by proxy, because every government has a certain amount of control over its over the web servers in its domains, and the Twitter response was a response to the inability to get information out through the other channels, and then they started putting out proxy server lists, but those were public, and so the Iranian government was able to shut down the public public servers that were being used as proxies. It was only until they got to Twitter that they came up with something that the Iranian government wasn't quite ready.
Because there's so many outlets and there's so many different ways in which it can be
I'm not
received.
sure they were fully aware of exactly how to do it. They had apparently planned for or anticipated the usual sort of web attack, but not.
And is this also mobile phones? They'd have to shut down the mobile phones from which people send their their Twitters, and maybe they haven't been willing to shut that
But
system
they
down.
did shut
But
down
there's a
text
dark side to
messaging,
all of this,
apparently,
right? Because again, you're dependent on this intermediary provider. When you talk about using your cell phones, you're also talking about enabling the tracking of a user via the cell phone. And so this is one of the differences, or one of the reasons why the intermediaries we have thought about, the ISPs or the website, are not the only ones that matter in the new age. It is the equipment providers, it is the backbone carriage providers, all these folks who are really a step removed from what we see. They're not the consumer-facing folks necessarily. They are buried. And so when the government or some private party acts on them to cause them to change their behavior or places requirements or is able to track or log, that is often something that is not visible to the consumer. It's not the same way that if you're blocked from a website, you may know that you were blocked from that.
Cliff, you
a different way.
Anne suggested some pessimism for institutional journalism, but some optimism for other kinds of journalism. Somebody who likes reading both my Washington Post and my Newsweek, you expressed some optimism in that regard. Could you give us an idea of why you think that those kind of, whether on the web or on paper, obviously?
And let me just clarify, too.
Yeah.
I wouldn't say that I'm expressing skepticism. I mean, I was just noting what's actually happening in the field. I do want to, point out, and a lot of the kind of citizen journalists, evangelists, often overlook this, that, it is still absolutely the case that probably 95% plus of the original journalistic content that the activists are relying on to talk about is coming from traditional journalism. So I just want to make that point. I think there is a real tension, and that there does need to be a solution to how you produce original content, which can't be solved just by the existence of the internet and the technology. So, yeah.
Cliff, what's the hope for optimism?
Well, a couple things. And, listen, I'm not taking a Pollyannish view. I mean, there are very
No
serious,
one would accuse you of that.
serious issues and serious questions. But I do think, again, so I was saying before, you start with the empirical fact that there is an intense and broad desire for quality journalism. And you can see that in the online numbers. And that tends to get overlooked in the discussion of this. And, the world doesn't have to be that way. It could be that everybody's going online and they're just going to kind of frivolous sites and nobody's really interested in quality journalism of the kind that the Washington Post and New York Times or a lot of other places provide. And it is exactly the opposite. So what's the problem and what's the future? I think a couple things in terms of kind of how we got here. I mean, one thing, there's obviously a lot of renewed interest in a paid model for online, and there's a sort of conventional wisdom that media did it to itself by not charging for content, both because that eliminated the need for print, and also you can't have a successful business model on something that's free. Well, that's not true. For a long time, broadcast television and radio were very successful business models, and they were free, and it was because of the advertising proposition. And here you've got a broad audience that's a quality audience, which should be very attractive to advertisers. I think you've had a couple of problems. One is that for a variety of reasons, the advertising rates online have been a tiny fraction of what they historically have been in print, and in part for a local newspaper, that was really the only way to reach the audience in that way. So that's been a problem. And you've had the collapse, for newspapers, you've had the collapse of classifieds, which has been a huge thing. You've got all those problems aggravated now by the economic crisis. Car dealers historically are huge advertisers in newspapers and magazines. And, you've got all those ripple effects from the current economic problems. I do think that given the nature of the audience for quality journalism, both online and in print, that we are going to see kind of innovative advertising models that at a certain point that provide much better kind of revenue base for these publications. And I don't think they're all going to be gone. But I do want to raise one important caveat on that, which is that one thing that I find very surprising often in these discussions is that there's a real disconnect between this discussion and sort of bemoaning the state of quality journalism and what people talk about in other contexts, such as the need to regulate online advertising more. And it's as though that wouldn't have any connection to the kind of financial health or the ability to develop innovative advertising models. And some of the things that sometimes are talked about with online advertising would actually strangle any possibility of kind of finding a viable economic model.
For example?
Well, I mean, for example, if we switch to an opt-in regime entirely, if there was a kind of strict ban on cookies online, and I mean, there are all kinds of other things we could get into that discussion, and people raise privacy concerns, but what amazes me is that these discussions go forward in separate silos, as though that discussion isn't going to have an effect on the very important question of whether we are going to be able to have viable quality journalism entities.
Paul?
I just wanted, Judge, to bring back up the other point that Cliff made at the beginning and see what other people may think about it. I agree with Cliff strongly that one aspect of the problem, going beyond daily journalism to other kinds of creative expression like music and movies, is the fact that these digital files can be replicated 1 million times for free, and that therefore the financial basis on which these things are done is being undermined severely by the fact that they're just being passed around or viewed on YouTube or whatever it may be. And so this is a problem as well, where I think copyright enforcement of copyright, while it obviously restricts certain ways that people express themselves on the internet, is fundamentally going to be important to allow the creation of new works of creativity that cost a lot of money to produce to continue to occur. I know there's sort of two views on that. There's another view to my left, I think, but that seemed like a topic we ought to at least talk about.
Well, I mean,
No,
I'm not even sure that it would be more than it's too much of a distraction to bring it up. But I mean, obviously, we have different views on the way that the copyright has been working on the internet, and to a large extent, we see a great deal of what we would think of as copyright maximalist behavior, both legislatively and in terms of really trying to get user content taken down. That is clearly a fair use and clearly is no threat to anyone's business model, and yet there is just a sort of a carpet bombing approach by some of the copyright owners.
I just got waved over here by our question controller. So I'm going to give Greg and Ann a chance to have a quick last word, and then we're going to go to questions. Greg?
I actually just had a quick question for Cliff, which is he hasn't mentioned Slate, which is another interesting place he worked in, which was an innovative online publication.
They did try to charge once.
How did that work out?
Well, and I would note they tried to charge when Slate was at Microsoft.
I vaguely remember that.
Yes. No, and it was a disaster. I mean, and people who went through that experience still have deep scars from it because the audience shrank to a kind of tiny group. And the model that Slate has had for the last few years with a degree of success, I'm happy to say, has been really focusing on building a large quality audience, making that attractive to advertisers, and experimenting with a lot of innovative advertising models, which I think is a real key to this. We have this new medium, and Ann was talking about all the exciting things going on in terms of content and that kind of thing. And I think it's very important when we talk about the business future that the business models, including within the advertising models, try to be as innovative as possible.
All right, Ann, you have the last word.
Well, yeah, I mean, the point I was going to try to make, and it doesn't sound inconsistent at all with what Cliff is saying, is that I definitely don't think we should think narrowly in terms of a new advertising business model. There may be many other models for paying for quality journalism that go beyond the traditional advertising model, whether it's online or off, and the very point that again some of the folks made about there being a stronger audience than ever for quality news ought to be kind of the stepping point, and also just to kind of go back to the point I was trying to make in just framing my remarks earlier, which is that, the government should not be a restrictor or a censor of content, but it should be an active promoter of speech. And there are many ways historically that these two points have been closely connected. I mean, one of the reasons that we had such a vibrant free press very early on in the Republic was because of postal service subsidies, right? I mean, the government could do things actively to help solve that, not by getting involved in content, but it could do things to help solve the crisis in journalism by seeding new models, creating new forms of subsidies for quality journalism.
All right. As an active promoter of speech, I'm going to now allow you to ask questions. Raise your hand, and then somebody will. Somebody where? Who's got the mic? We'll come around all the way in the corner back there. Is that Peter? Yeah.
So just picking up on Ann's last point about the government as a promoter of speech, I'm wondering, is this on?
Yes.
It's on.
I'm wondering if there's a tension between various panelists' expansive view of the First Amendment and the Internet and government regulations of Internet technology to preserve open networks. Or I might even say government regulation of cable systems to keep government channels in basic cable. If we're analogizing the Internet to the print media, aren't the owners and operators of network systems the equivalent to publishers? And might there not be a problem? And I say this hoping that there will not be a problem, but I wonder if there would be a problem in saying to owners of networks, you have to maintain some version of network neutrality in the name of free speech.
Who wants to answer that one? Paul? You must have an answer.
Well, yeah. I mean, I think that in terms of First Amendment doctrine, there's a distinction that's been drawn between telling an operator of many channels that you have to have a few additional channels on there that you may or may not want to otherwise have, which goes back to the Turner case, cable companies must carry cases, and something much more directly involved in content regulation. And so, I mean, I think ultimately the answer probably will be if there is things that government can do to make sure that people can get access to things through these intermediaries, if they do it in a way that doesn't get toward content regulation, I think the courts are likely to allow a certain amount of that.
And if I could add, I mean, the problem still is, while I agree that there's an issue there, you have too much government management and regulation of content, the fact is that we already have, you use an example like the Children's Internet Protection Act, which mandates the use of censorware or blocking software in libraries and schools that receive federal funding. We've got a far, far more direct sort of government thumb on the scale of content there than in the other situation.
All right, another question? How about come over to this? We'll go back and forth. Make it. Let's be fair to both sides here.
Still don't like losing things.
We're nonpartisan in that way.
If a newspaper publishes a classified advertisement which is racist or sexist or violative of anti-discrimination laws that we have fought for over the years, it will be punished by federal entities and others promptly. But if an internet service provider publishes the very same racist or sexist ad, Craigslist and its colleagues will assert that Section 230 protects them from any liability, guarantees them for immunity for it, and has successfully argued that in certain contexts. Is it time? Judge Gelfand has referred to some of the takedown requirements and the disclosure requirements as to anonymous sources of adverse comments. We know about the case involving the Yale women law students. Is it time to revisit the scope of Section 230, which, after all, is not the First Amendment to the United States Constitution?
Well, I mean, I will say, as I said at the beginning, that in general, I think Section 230 plays a very, very important role in allowing the Internet to reach its full potential. I think there are particular issues and questions that come up, and certainly the question of differential treatment of classifieds. And I know, and certainly that's an important business issue as well as an important legal issue. So, it doesn't mean that sort of all questions are off limits, but I do think that basic principle of broad immunity with issues and problems that can come up has served us very, very well, and you would have, as was also said by others on the panel, a very different internet, because one of the most, if you didn't have it, because one of the most kind of fundamental features of sort of enabling speech by others, you would have many sites and for very reluctant to engage in it. And I think that would be to our loss in terms of free speech generally.
Okay, you want to go over on that side there? Somebody in the back there?
I just wanted to follow up on the questions about the economics and the business model. It would seem that certain types of speech on the internet are prolific, and the blogosphere is full of opinions of people both in organizations as well as citizens. My question really goes to investigative reporting and investigative journalism. If you think about the health of a democracy, it is absolutely essential to have a vigorous press corps of some sort doing the hard stories that take months to develop. The Watergates, the Pentagon Papers, the Abu Ghraibs. I mean, those stories aren't going to be generated by the blogosphere. Those are generated by shoe leather in the basements of city halls and people doing FOIA requests and spending a lot of time digging those stories that are essential for us as citizens to know what our government is up to. So I'm curious if the panel has thoughts about the future of investigative journalism if newspapers fade away, and what's going to take the place of those to investigative journalism.
One of the things that's taking the place, at least maybe in the short run, it's not clear this will be a workable model, is sort of nonprofit efforts to fund this from rich people setting up investigative journalism houses where they incorporate as a C3 and they run themselves that way to try to fill that gap.
Isn't that what rich people were doing when they bought newspapers and lost money? It was a similar thing, didn't they?
It could be. Yeah.
But I mean, is that enough? What I'm asking is that enough? I mean, is that enough to sustain the model?
Yeah, there's a question as to whether it's a sustainable model. I mean, Paul, did you finish?
No,
I was just going to say, in fact, what you see if you look at, kind of the models emerging is that there has been more attention paid to that problem and some interesting models, including the nonprofit ProPublica model, that Paul mentioned, and some others, to fill the gap in investigative journalism than there have been on several other critical journalistic functions, and that's what I mainly wanted to point out, because there's a lot of attention been paid to this challenge of, what happens if we lose all the investigative journalists. But the other thing that's happened is that we have seen an utter decimation in regular beat reporting on state capitals, right, and on federal agencies, right, and two other kind of very critical areas where we just have to figure out, some response to that. And I don't think the response just has to do with what the new model for journalism looks like on or offline. It also does kind of merge into this area about, with new technology tools, what is some new model that can both make it possible for regular people to access and analyze government data, right, in a way that's different than just reading an article in the newspaper. But I did just want to point out, I think it does go beyond the investigative journalism.
Paul, can you say something more about examples of the nonprofit that you were talking about?
Well, I think ProPublica is the most prominent one, and it is something that's only just emerged in the last year or so, where people are trying to supply this. I'm not sure if I have much.
How do they get? They get donations online or from foundations, or
it's one single donor. It's the Sandler Foundation, pretty much. Yeah, there are a couple of other models. Some of them are combining with journalism schools. There's a great center called the Wisconsin Center for Investigative Journalism that has a great model. There's the Voices of San Diego that I talked about as another investigative journalism focused model that's operating out there. So there definitely are a number of interesting models.
The other thing people,
if I could say, I mean, I used to be a reporter and I used to do this kind of work, and honestly, I do not blame the internet for this problem. I blame TV. I mean, I was a reporter. I was a reporter in
Guess that's a question of age.
in the late '70s and early '80s as in print. And I was one of these people who would go down to the state capitol. This was in Washington, and go through political disclosure forms. And you'd spend 3 or 4 hours going through the boxes just to figure out. That stuff is cheap, but is not really all that hard to do. And if you're only in a print world, it gets done. But when the emphasis is on the sound bites and the emphasis is on a photo op, there is no photo op for this kind of stuff. So my main point is that the seeds of that problem, really came about in the early '80s, at least from my perspective as a former journalist. And what we're seeing now is the culmination of that trend.
Everything went downhill after the early '80s.
Can I just add one quick point about ProPublica, because I think it just highlights that there may be some interesting combinations. It was announced this week that AP is going to enter into a relationship with ProPublica and some of these other new investigative entities to carry their investigative journalism projects.
All right, I think we now have 2 mics out there. Is that right? Okay.
I'm sure which
Both
one.
of you get it to ask a question. You ask one, and then you can ask.
As the attorney for sites like Daily Kos, my clients love Section 230, but the auto-admit example, I think, reveals 2 of the assumptions behind Section 230 that aren't necessarily true. Number one, that site proprietors are generally going to be interested in having responsible sites that don't have a lot of trash on them. And number 2, that when push comes to shove, you'll be able to trace down the identity of the offending party. When you have sites that don't track commenter identity with a verifiable email address or something like that, then you've got victims out there who have no recourse. So I guess the question is there a possible fix to Section 230 that would require, sites perhaps above a certain size to track commenter identity through tools like TypePad or something like that?
Greg?
Or are we better off just leaving these plaintiffs without recourse?
Greg, did you?
Well, go ahead.
Well, I don't have sort of a broader answer to your question, except that it seems important that in certain circumstances that identity matters and that there be some ability online to verify people's identity. It doesn't have to be the whole identity. It can just be parts of identity, like age, that can be significant. But, there are dangers with that, too. It needs to be voluntary in certain ways. Anonymity has its place. But also the opposite of that is the need to establish reliable identity.
Lee, you want to jump in there?
Yeah, I want to jump in just because there are a couple of different, interests involved here. One is an interest in compensation or remediation. Another is an interest in attribution. We at EFF, and I think a lot of free speech organizations, we're we guard the ability for anonymity on the internet very, very jealously. And the idea, this is one of the areas that, we would, sort of butt heads with Greg on, is the whole idea of reliable identity on the internet. I think that there are real serious free speech problems with it. So, one potential answer, and this has been suggested in the law review literature in all sorts of cases, because it's not an internet problem. Again, if you have a judgment-proof defamer, you can't squeeze any money out of them. All you can do is perhaps shame them a little. But insurance of some sort is socializing that risk, having some sort of social or public subsidy for free speech is not an utterly insane idea, and could at least provide some measure of compensation for those who have been wrong without necessarily creating an infrastructure of identification that would destroy anonymity on the internet.
I'd just like to add to that there's been a cultural shift on anonymity versus identity. If you look at MySpace, that grew up in a culture primarily of anonymity. People didn't use their real names. Facebook grew up very much in a culture of using your real name. You grew up in colleges and universities where everybody knew or was able to know everybody else, and you only invite people that you know, and they all use their real names. And it's a very different kind of dialogue. In some ways, I've heard that Facebook does not have the sort of misbehavior problems of people, defaming or being rude or putting, unpleasant things on their pages, because they are all using their real identities. Whereas in other circumstances where people hide behind aliases, it's a different culture and different issues arise.
Pass the mic down. Thanks.
Thanks very much. This has been a great panel. I think it's kind of interesting listening to you talk about investigative journalism, because it's almost like this foundation that you're talking about, this nonprofit you're talking about, is kind of the beginning of a sort of slow news movement. It's sort of similar to the slow food movement that was in response to fast food. And, we went sort of headlong into fast food, and then we discovered far too late that there were many problems that came along with that. And unfortunately, when I say too late, it's going to take us decades to recover, really, as a people, in terms of our health. And I don't think what troubles me about discussions about the need for slow news and what's going to happen to newspapers or what's going to happen to investigative journalism is that I don't, at least I'm not reading a lot in the paper about politicians taking a really serious look at models for example, public funding of slow news. And, we can't afford to go, a couple of decades without solving this problem, because our democracy can't take it. So is anyone talking in a serious way about, when I lived in Britain, I was a student in Britain 20 years ago, and there was, for example, in those days, a TV, not a tax, but it was a use license, so that your TV wouldn't get BBC, or there were only like 4 stations, but you actually couldn't switch it on without paying something to use the box. And then, what you actually watched on the box was whatever, but they used that to fund, things that not necessarily everybody would watch, but that was necessary for democracy, namely BBC One and BBC Two. So I'm curious about whether whether anybody's really taking very seriously the impact on our democracy to the point where they're drafting legislation, talking about legislation, circulating it, what's happening on Capitol Hill right now.
Yeah, I would just jump in and say certainly many, many people are doing nothing but wringing their hands and putting their heads together to try to figure out different approaches to the crisis. I don't think it is – I think it's at that level of turmoil where it hasn't quite reached the consciousness of our friends on Capitol Hill. And I think it's a very good point that you're making. There are many, many sort of foundations and journalism schools and newspaper organizations and that have been doing nothing but sitting in rooms trying to come up with different solutions. Some of them I think very good, and I think that I would sort of say even by early next year, my hope is that you're going to see legislators becoming more involved. And there's been a lot of talk about trying to push for some kind of independent commission to look into the crisis in journalism, and so that might be an obvious next step that's more kind of research oriented, et cetera. There's some great projects going on right now. Columbia Journalism School is doing a great deep analysis of the innovative models that are emerging, which it's going to be publishing. There are many things like that going on. The Knight Foundation has a whole commission into investigative journalism that has just put $15 million in. That was just in the paper the other day. So there's a lot being looked at, but you're making a good point that we also need to get our legislators involved.
But can I just say one thing, though, about getting the legislators involved in the idea of funding? As serious as the problems are now, I just have to say I think that relying on government to fund journalism would be a terrible idea, and it would be sort of antithetical to our whole sort of First Amendment concept and the relationship between the press and the government. And you get a glimpse of that. There was an op-ed piece, I think, by Senator Cardin of Maryland, and I may be butchering this a little bit, but there's a bill that he has put in with others, which is very well-intentioned, or he's working on a bill that would either make the press tax exempt or give it tax advantages for that, tax benefits for that very reason. And you read this op-ed, and it comes to a certain point, and it says, of course, any entity getting this tax advantage would be prohibited from having editorials endorse political candidates. And it just gives you a sense of why that's a terrible idea, in my opinion, to get the government in the midst of it.
They're already in the middle of it.
No, but then there's the whole question of who the press is. If you tried to figure out a way to fund it in that way, one of the things that the Internet has done is blur the line between the press and everybody else. You have bloggers who are invoking reporters' privilege and things like that now. It's a whole different world. And it does seem like much more consistent with our culture to have sort of the PBS model than the government model, which is to say some people set themselves up as the watchdogs of something that a lot of people care about, and maybe they can raise a lot of money that way. The one thing the Obama campaign showed is the Internet may defeat a lot of economic models, but it could also raise a ton of money, $10 at a time, if you have the right kind of organizing around it. So,
but I would add, by the way, that I don't think, from my experience, the Hill is completely aware of these issues, and they think about these issues when we talk to staff, et cetera, especially the one you mentioned before about regulating of online advertising versus the death or health of content providers. When we talk from a privacy perspective with folks on the Hill about online behavioral advertising, we are always met with but aren't you going to kill these websites? Aren't you going to kill the New York Times? Don't you? I'm not sure how much they care about the New York Times, but they assume we do, and so they will say, well, what are you going to do about it? Isn't restricting online advertising going to do that? And our answer is usually, well, there are definitely some difficult issues, but you should not be building a business model on the backs of people's privacy and allowing the kind of tracking and the kind of behavioral recording, which is natural and technologically really, really cheap online, that is not possible in any other medium, to simply drive the bus. And so at some level there is a certain amount of, well, this is a really good opportunity for us to use the financial crisis in order to promote very, very lax rules or the absence of regulation of this kind of advertising.
Let me ask, do we have time for one more question? Yeah. All right, so only the very best question. And who is that? Who's got the very best? One of these two women right here. Let them decide. We don't know.
Maybe people can vote online.
Flip a coin.
In stereo.
You can go. Well, my question was about sexual predators on the internet. There's a Georgia law that has required sex offenders to not only turn over, where they live and everything like that, but also all their usernames. And I think this is clearly wrong. Their passwords. Now let's take the passwords out of the equation and just say they have to turn over their usernames. How strong is the right of anonymity on the internet? And should that trump attempts to track what sex offenders are doing to make sure that they're not on websites, in chat rooms, doing what they're not supposed to do? How does that balance out?
Well, all right, I'll jump into that one. I guess in part, my answer in thinking about it would be, it depends what the predicate is. I do think the Supreme Court has emphasized there is a very important First Amendment interest in anonymity, and that it serves, very positive benefits. The Federalist Papers, the authors were pseudonymous, and so on. At the same time, it's well established that if there's a sufficient predicate and criminal activity or something like that,
and you're on parole, under
yeah.
some kind of supervision.
So I'm not sure exactly what the predicate would be, but I think that's sort of the framework for analyzing that issue.
It's a tricky practical issue. There's people who are on parole and people who are off. There's all the different states and the different databases and how do you get them together. There's the fact that the internet doesn't stop at the borders of the United States. That's one of the reasons why service providers think it would be very helpful to have reliable means of identifying people, because legislatures do think it's a great idea to mandate that lists be established in databases and people be tracked and excluded, and it's a very difficult problem to manage.
Since you were so nice to allow her, I'll let you have one more, and Lee will answer it, whatever it is.
He is the right person to answer it.
I'm never the right person.
Actually, we were talking about how the internet has been established as being a free speech platform in Reno versus ACLU and in a lot of other cases. But to what extent has the First Amendment been diluted for purposes of individual people communicating on the internet, where some bad effect has happened as a result of that communication, in terms of vicarious culpability. So, for instance, somebody puts on a website some demonstration activity or something, and it's a totally legal demonstration, and something happens at the demonstration, or several weeks later, somebody vandalizes somebody's house because, for whatever reason. Now, to what extent is that person who now posted that information on the internet vicariously culpable or vicariously liable for some third-party action that they had no control over?
I guess I would say that we're still doing pretty well from a free speech perspective on that, simply because we have such good law from before, Brandenburg, various kinds of laws that protect against, unless the speech is highly likely to cause imminent harm. It's going to be very, very hard to punish the speech or find the speech to be, liable in tort as having caused something later. And we've seen this in the media cases with various kinds of copycat and, Judas Priest songs that made people do things. And there's a pretty strong First Amendment protection there. So I am not yet worried about that sort of thing. Although sometimes you do have the incursions in the area where it's information that contributes to a particularly controversial kind of harm. We have out in the Ninth Circuit the so-called Nuremberg Files case involving the Planned Parenthood and the deaths of or threats to abortion providers, and those are very, very difficult cases. But most cases don't get that hard.
Does anybody else want to answer that? No? All right, that'll be the last word. Tom, what time is the next event?
10 minutes to mingle and lunch at 1:50.
Thank you all for coming.
Yeah. Great job.